was a hearing on day 2 about the pleas that have been filed in the Waqf case. And what has happened is that the court has said that the Waqf by user provision will not be implemented, which means that no properties will be denotified under that provision, at least for the next 7 days, and also has put a stay on a certain other provisions, the details of which we'll get from our colleagues Harish and Dipankar. Harish, tell us the highlights. Dipankar, if you could take that question.
Well, today the Supreme Court, the Solicitor General gave an assurance to the Supreme Court where he said that there will be no further appointments in the Central Waqf Board or the State Waqf Board, and the properties which have been already registered, which have been notified or decreed by the orders of the court, they will not be notified. The Waqf properties will not be notified. These were the two assurances that the Solicitor General of India gave to the Supreme Court, and after that the Supreme Court of India has sought a written reply from the Union of India as well as the state players who were the respondents in the petition, and they have given 7 days time to these respondents to file a proper reply to this petitions that have been, this batch of petitions that have been filed by the petitioners, and a 5 days time further has been given to the petitioners to file a reply to the response of the Union of India and these respondents. So these are the broad thing that had happened. The Solicitor General gave these assurances, giving sort of an undertaking before the Supreme Court of India that there will be no further denotification of the Waqf properties which have been already notified, gazetted, or have been decreed by the orders of the court, and there will be no further appointments in the Waqf boards, which are the Central Waqf Board or the State Waqf Board. So these were the main highlights of the case that had happened today. It was a very brief hearing that had happened before the Supreme Court today, and these assurances were given, and the Solicitor General sought 7 days time to file a complete reply, a comprehensive reply to the
how this
petitioners.
Seemingly a major climb down from what Supreme Court's tone and tenor suggested yesterday.
Yes, Priya, in fact, the biggest observation from the Supreme Court today is that we do not want things to change. We want that the prevailing situation should continue so that the rights of the parties shall not be affected. So at this juncture, we should remember that Solicitor General Tushar Mehta said the court should also remember the violation of rights of thousands of families whose properties have been grabbed. And Solicitor General tried to convince the court that this is an act passed by the, discussed by the JPC threadbare, and also there were 38 hearings. 29 lakh suggestions were invited. The committee had gone to all states, and in fact the Solicitor General to some extent could persuade the the Supreme Court to come down a bit. In fact, yesterday it was the Supreme Court which was considering to pass an order. That is very different from the Supreme Court not passing an order and merely recording the assurance of the Solicitor General that number one, that no work property which was decreed by the court or gazetted, registered or notified will be denotified. Number two, that no appointments will be made to the State Waqf Board and Central Council. But there is a big order yesterday the Supreme Court was contemplating, that is that allowing the clause which gave supreme power to the collector to adjudicate disputes, because Kapil Sibal, representing several petitioners, had argued that this means that the government is both a litigant and a judge, because a collector will obviously, in a dispute between Muslims and government, will side with the government. So that has been untouched today, because remember, Priya, most of these properties under dispute fall in this category, because collector can adjudicate disputes regarding government land or also where there are disputes. it is this category of Waqf properties which are being under the scanner of this particular act. And yes, we can say that government can still act against unregistered properties, but in the fitness of things, when the sensitive issues, and this act is under the scanner of the Supreme Court, since the matter is sub judice, government will not act. Even the Solicitor General Tushar Mehta went on to say that Supreme Court does not have to issue a stay because even otherwise till the next date of hearing, we do not contemplate to do anything. So in a way, it is a climb down by the Supreme Court, because it is Supreme Court, it is not the Supreme Court which has passed an order. Supreme Court has merely recorded the assurance of the government that it is holding its hands for now as far as these two clauses are concerned.
Stay on with me, Harish. Let's play out the reaction coming in from the lawyers after the hearing took place.
Today, the Honorable Supreme Court, when resumed its post-lunch proceeding, the Solicitor General of India gave very categorical and specific answer that so far the appointment in Waqf Council and Waqf Board is concerned, the government will not make any appointment till the next date of hearing. The second was regarding the Waqf by user. So the Solicitor General said that those Waqf by user which is registered and gazetted, that will not be denotified till the next date of hearing.
Harish, now tell us this. This act, any which ways, does not have any retrospective effect. So how crucial is the distinction that is being made by the lawyer there over gazetted properties, registered properties, and the rest of them?
Can you please repeat the question?
Right. So, we just played out a bite from a lawyer. He's the advocate who's representing Hindu Sena in the Supreme Court in the Waqf case, who says that the Solicitor General has said that government will not denotify the properties under Waqf by user which are registered and gazetted till the next date of hearing. Now, given the fact that this new law is not retrospective in any case, how significant is this distinction?
Yes, it's a very relevant question, Priya, in fact, but we should remember that as per this clause, especially the clause regarding Waqf by user, the entire act is, the government said that it will be prospective, but we should remember that there are certain retrospective clauses which says that properties in dispute, number one, and the encroachments into government land, Waqf on government land, that can be, its validity can be assessed by the collector. If there is a dispute, the collector can come in. This is what this act says. So these only other parts are prospective. These two parts, like wherever there is a dispute, wherever there is no document, wherever there is, it's a government land, this act becomes retrospective. So in that context that this particular lawyer is saying that now that the Supreme Court has said that these Waqf declared by courts which are gazetted, which are notified, cannot be denotified. Therefore, the unregistered Waqf properties which do not have documents, that the government can go after those, the government is free to go after those properties. But in the fitness of things, when the matter is sub judice, and also the Supreme Court is suggesting tweaking of some clauses, ideally the government will not go and then act. So in my view, till the matter is sub judice, the government is not expected to take much action as far as this Waqf Amendment Act is concerned, and at least till the next date of hearing, next interim order, we can expect a status quo as far as not only the clauses which the government dealt, but most of these clauses on which yesterday the Supreme Court had raised questions.
All right, and now the opposition parties, many of them have also implemented themselves in this case. They are also the ones filing petitions. Let's listen into the reactions that have come in from them.
This is not reform. It is retaliation in the guise of reform. It is retaliation meticulously scripted, strategically timed, and constitutionally questionable. It is an exercise in erasure. Behind the bland language of governance lies the bold ambition of control. community rights are being redrawn with bureaucratic pens. Let us be clear, this is not about improving institutions, this is about infiltrating them, controlling them and closing them.
The Honorable Supreme Court, as rightly pointed out by my counsel, Mr. Nizam Pasha, the Supreme Court has said that the Central Waqf Council and the State Waqf Board will not be constituted. Waqf by user cannot be deleted. During the deliberations of the Joint Working Committee, I have given a Dyson report opposing all the amendments that were proposed by the government. And during the debate in the Parliament of the consideration of
Dipankar, would it be right for the opposition parties to say that what has happened in the court in the last 2 days, yesterday and today, is some sort of a victory for them?
Well, we can clearly see that the opposition has been saying that it is a victory for them because in a way that the assurances that the Solicitor General of India has given to the Supreme Court that there will be no denotification of the properties which are registered, which have been notified or decreed by the courts, and that there will be no appointments in the Central Waqf Board or the State Waqf Board. So these assurances may be treated as a victory, an interim victory, as status quo has been maintained in a way by the Supreme Court of India, and the implementation of the new acts are more or less stayed in certain ways in the provisions that are there. So it can be said that it is a victory. Certainly the opposition and the opposition lawyers, the petitioner lawyers who were there, they in their statements while we were talking to them, they were treating it as a victory, that the assurances that the Solicitor General of India has given, which have been recorded by the Supreme Court of India, is a victory for them.
The next hearing in this matter is to take place on the 5th of May, but politics hasn't stopped. Listen into what Aam Aadmi Party leader Amanatullah Khan says. He's brought in religion into today's verdict as well.
जो वकील भी पेश हुए, हमारे वकील और तमाम सीनियर वकील, सारे वकील पेश हुए, उन तमाम वकीलों का हम शुक्रगुजार हैं और हमें सुप्रीम कोर्ट से यही उम्मीद थी कि फैसला हमारे हक में आएगा। जिस तरह से आज केंद्र सरकार के वकील ने कहा, कल जो जज साहब ने बात कही थी कि हम जो वक्फ बाय यूजर प्रॉपर्टी हैं इनके साथ कोई छेड़छाड़ नहीं करेंगे, रजिस्ट्रेशन में किसी किस्म का कोई छेड़छाड़ नहीं करेंगे, और जो वक्फ बोर्ड जो बनाएंगे उसमें किसी मेंबर को ना ऐड करेंगे, ना ही कोई मेंबर हम बनाएंगे, ना ही कोई वक्फ बोर्ड जो है हम फॉर्म करेंगे। तो 8 दिन का 28 तारीख को नेक्स्ट हियरिंग है।
Harish, it's very interesting that we hear from Amanatullah Khan. He himself has been heading the Waqf board in Delhi, has been facing cases for mismanagement of Waqf properties as well. He even went to jail for that matter. And today he comes out to say that everybody rose above religion to make sure what happened in the court.
Yes, that's right. In fact, as Dipankar said, this opposition is bound to take these orders coming in from the Supreme Court, especially the kind of observations the Supreme Court had made yesterday, like asking the Solicitor General if you will ever allow a Muslim member or a non-Hindu member in a temple board. And also the Chief Justice saying that how can you suddenly take away a Waqf by user which has been in vogue for more than 100 to 200 years. In fact, the Chief Justice also went on to say that prima facie we agree with the argument of Kapil Sibal that the Waqf is a Islamic concept. It's a part of Muslim personal law. It's a dedication, a donation to Allah. So these are the very arguments made by the opposition in parliament also, including Amanatullah Khan, has been repeatedly saying this. Several leaders who have moved Supreme Court also, like Asaduddin Owaisi, Mahua Moitra, Mohammad Javed, and Indian Union Muslim League, All India Muslim Personal Law Board, all of them have been making such arguments. So some of the arguments and some of the oral observations made by the Chief Justice of India yesterday and today is music to their ears. So they are bound to claim all this as a victory. Even today, the Supreme Court has said that we have to ensure that nothing should change, and what is prevailing today should continue, so that the rights of the petitioners, that is mostly Muslim community, is not affected. And also as you said, it is very correct that Amanatullah is facing criminal charge as far as was property misappropriation is concerned. So it is added happiness to him, as according to them, Supreme Court has, in a way, though the Supreme Court has only recorded the assurance of the Solicitor General, in the end of the day, yesterday's observations and today's order is in favor of the opposition.
All right. Thank you, Harish and Dipankar, for